In recent news, Google and Apple have been engaged in patent litigation, and in the German court ruling, the courts have stayed Google versus Apple over the push notification patent. It turns out that the ruling in this case is likely that the patent is invalid, but both parties have agreed to stay the case, which essentially means that the case is temporarily halted for the time being. But what's interesting is that this case has a real history in the courts, particularly surrounding the push notification patent. And a real milestone for this patent and the case in general happened back at the end of 2008 in December, in which the UK courts had ruled that this patent was invalid. And so, as a result of this, Google was Google in this case had forced Apple to turn off its iCloud mail push notifications. Primarily, the reason for the invalidation of the patent was that it lacked novelty and obviousness. So now this same patent is being investigated in German courts, and it seems that the direction of the ruling is heading towards invalidity. But for now, there's been a stay that's been granted for this case. So I guess this case just really brought us some thoughts regarding the enforcement of patents. It's just really difficult to be able to effectively enforce and assert intellectual property rights. And also, this patent was something that was widely used by Apple, and now we're turning to courts in different regions, such as the UK and in Germany, and we're seeing that what constitutes as novel and obvious in the US might be different for what constitutes that in different regions.